We are coming back for the second part of our seminar. I would like to thank again our sponsors, Jus Brasil, Legal Code, Urbano Vitalino Advogados, and LegalRuleML, who made this event possible. And we are now moving for the second part, which will begin with Professor Adam Wyner. He is an associate professor of law and computer science at Swansea University, UK. He holds a PhD in linguistics and computer science, and his main interests include knowledge extraction, representation and reasoning, natural language processing, argumentation, case-based reasoning, and machine learning. So Adam, please, you have the floor.
Great, thank you. It's a pleasure to be here. Thank you for the invitation. And I think it's a really good idea to have events like this. Just confirm that you can see my slides.
Yes, perfectly.
Perfect, great, thanks so much. So I was invited to speak about legal argumentation. I've done some work in this area and participated in some projects and some meetings and things like that. So this will be a brief high-level fly-through about some aspects of legal argumentation. I realize that there are some things that I don't talk about in this slide stack. I might mention those very briefly, or people might ask questions about it. It's a certain aspect of legal argumentation. So we could really start off with Leibniz, who kind of introduced this idea about calculating over arguments. So the only way to rectify our reasonings is to make them as tangible as those of the mathematicians, so that we can find our error at a glance. And when there are disputes among persons, we can simply say, let us calculate without further ado to see who is right. And this statement from quite a while ago really sticks and is kind of an inspiration behind contemporary approaches to formalizing and representing legal arguments. So let's just talk about we'll talk about the general context, some formal approaches, and a short example of argument analysis. I'll also touch briefly on argumentation schemes, what they are, what they're used for. Talk about where are legal arguments, what's the use for the analysis, and how are they found. So what are legal arguments? People who are lawyers have some ideas about this. We can also broaden up this point of view from just legal arguments to arguments in general, but here we'll say some things about legal arguments. So we have legal arguments in legal cases where, for instance, you have a plaintiff and a defendant, and they have different sides in a legal dispute. Their lawyers are representing them, and each side is only representing their point of view against the other side's point of view, and vice versa. So it's an adversarial kind of context. The goal is to find one party guilty or find somebody else innocent or establish some kind of penalty. And over the course of the discussion, if you call it a discussion, but it's a debate or an argument, each side presents a range of legal arguments and evidence to support their particular position. So we might say briefly that an argument is simply a statement that's given some premises from which a conclusion follows. And we'll have another specific example of that shortly. Another place where we could talk about legal arguments are in policy consultations. So here, for instance, the government is interested in some kind of policy or taking some kind of action. Let's say they want to build a new airport, or they want to decide whether or not they should provide legislation to subsidize farmers, or what the position should be of the government in terms of providing funding for education and under what terms. So what the government does in some respects is they go out into the community and they have a list of, let's say, 10 or 15 kinds of questions that they want to have answered. They solicit answers to these questions in order to get public opinion, okay? And what they get in return are a whole stack of documents where different interested parties write their answers to the questions, and then the government will take all of these statements that are contributed by interested parties and try to do some analysis to identify what are the various positions that are held across this community, both for and against this particular proposal. And based on that, the drafters of a particular piece of legislation or proposal will form a white paper, which will then put forward a certain number of policy proposals and specific, and that then will go through a process which can then be transformed into a piece of legislation or drafted into some regulation. So as you can imagine, this is a very significant task to carry out because there are divergent opinions about what to do and why to do it, and what are the sort of underlying justifications or motivations for their particular points of view. So this is another context in which we could talk about arguments. And these are particularly legal arguments because they're in a legal context of drafting legislation regulation. Let me just add one other remark before I move on to this slide. Arguments are found all over the place. Anytime where there's a difference of opinion, or in a sense, anytime where you're trying to come to some decision about some matter, and there are some differences amongst the various parties about this decision, there could be some version of argument. An argument is not always an antagonistic discussion. You can also look at arguments where you're just trying to find out information in order to come to some common understanding of things. Another place where you could see arguments are, for instance, in consumer websites, where there's a discussion about what item to buy. And if you look, for instance, on Amazon, on the, about a particular consumer item, let's say a camera, you'll see on the, below that, there'll be a variety of comments that people contribute both for and against buying that camera. This too can be seen as argument, and this too can be seen as something that you would like to reconstruct in some structured manner. So what's the use for analysis? Well, we have legal cases which are very long and complicated, and they're very intricately, chained together. All the arguments are chained together. And what we can see here is that the information is distributed amongst various parties and distributed over various texts or various kinds of exchanges in the discussion. So there's this distribution problem. And what you would like is that for the various parties to have the opportunity to kind of reorganize and restructure all of that information in a coherent and cohesive manner so that they can really get a view into what it is that they're discussing and what are the reasons for coming to a conclusion. And the same thing is going on with policy consultations. And the same thing is going on for camera websites or consumer websites where there's a great deal of information that's distributed. Again, just put yourself in the shoes of wanting to buy something. You go onto Amazon, you're looking at a particular camera, and you find that there are 1,000 comments about that camera for and against in different respects. How many people bother to spend all the time to read through those 1,000 comments to figure out what it is that they want to do? Unlikely that anybody does, even though those thousands of comments could be very informative with respect to your decision, okay? So it would be nice to have a tool that will pull some of these things together. As I've mentioned, there may be various places where we find arguments. I've mentioned a couple of them already. And how do people kind of come to organize these arguments? Largely what's going on right now is that the methodologies for analyzing and organizing arguments are manual. That is, people will sit down together and say, okay, there's this point of the argument over here and that point of the argument there, and these 2 points are the same kinds of things, and they will manually reconstruct the argument. There's a great deal of work, I don't discuss this very much here, to try to apply natural language processing techniques on a corpus of argument statements in order to carry out this task of summarizing and reorganizing argument statements. So that's just a little bit about where arguments are found and a little bit about the purpose that might be given to reconstructing them, and a little bit about how natural language processing might be applied to reorganizing arguments. We can also talk about some of the formal analysis that's applied to arguments in order to sort of reconstruct the pattern of reasoning that we've got. So let's just first look at a little bit of an abstract about what an argument is. It's reasoning essentially from assumptions or premises to a conclusion. Here we have this reasoning pattern called modus ponens, where P is an assumption. If P arrow Q, that means if then, right, is a rule. And where you have these two assumptions, if that is P and the rule, you can conclude Q. Okay, you can in effect separate off Q as a conclusion. This standard rule that we know from propositional logic. We can call this reasoning pattern, modus ponens, an argument scheme. That is, it's a pattern of reasoning, and we will talk about some other patterns of reasoning later. This is set within a classic logic, that is propositional and predicate logic, that's known to be monotonic. That is, inferences that are once made cannot be withdrawn in the light of new information. An area where monotonic reasoning is extremely useful is in mathematics, right? Mathematics, once you sort of provide the proof, maybe there's an error in the proof, but you generally would sort of clean it up so that there are no errors in the proof. And then once it's done, and you constantly can build and add to this mathematical knowledge. So we talk about these inference rules as being strict. If the antecedents are true, the consequent must be true as well. And we don't add and remove rules. So that's what we generally do in classic logic. The problem is that legal reasoning is not like classical logic, because it's possible for inferences to change once new information is added. So you can have new evidence, you can have new source material, the legislation might change, there may be a change in legal argument. So there's this dynamic aspect of legal reasoning. For instance, as well, legal rules can become invalid, even though they remain on the books. They're invalid, they're inapplicable, right? And this is something that Monica has worked on in LegalRuleML, of annotating rules as being effective or ineffective. We also talk about legal rules as being defeasible. They hold in normative circumstances, but for instance, there may be rules that are said to hold, but so long as there are no exceptions, right? So that we know in reasoning about rules in the law that there are numerous exceptions that arise. And so, you can say a rule usually applies except if somebody has a particular status or something like that. Another instance is that rules may be arguable. That is, for instance, in the United States, there's a whole bunch of legislation about search and seizure. And there's an important difference between searching somebody's home, in which case you need to have a legal warrant and a justification for going into their home, versus search and seizure within a car, in which case it's understood that you don't need a warrant. And in a sense, a car is a much more public space. What do you do, though, when you have a mobile home, which kind of crosses over this boundary of being a car versus a private home? And there's a whole discussion about what rules apply there, and there has to be some argumentation about it. I mentioned already arguments. Another aspect of legal reasoning that's problematic for strict logic is that legal arguments can and often are contradictory. So in an adversarial setting in court, one side argues against the other, and both sides may just actually be calling one and the other a liar, right? Or saying the facts that are presented by one side are contradictory to the facts that are presented by the other side. The problem here is that we, as arguers, are able to sustain discussion even in the face of contradiction. Logic does not allow this. Logic will simply, in a sense, stall as soon as it gets to a contradictory setting. So this is a basic principle of classic logic that is simply not able to overcome. So one of the important aspects is to find some treatment of contradiction so that you don't simply stall further discussion. Another aspect of legal reasoning that we see is that there can be different proof standards. That is, a claim or a conclusion only needs to be demonstrated to a certain proof standard. So for example, in the United States, there's a difference between criminal and civil lawsuits, and they apply different standards. You can be, for instance, in a criminal suit, if you're accused of murder, you have to have it beyond reasonable doubt. but you can also take this to a civil context where there's only the preponderance of evidence that may hold in order to convict you of, let's say, manslaughter. About the same facts and the same crime, depending on the context, different proof standards may apply. Another aspect is that we find that different, if there may be two rules that apply, and yet there is rule prioritization. And we'll take a look at this a little bit later, but one of these is lex superiori, where laws that are promulgated from superior courts trump rules that are promulgated by subordinate courts. So even though the two rules hold, there's a kind of a dominance relationship between the rules. So there's this whole space of problems with legal reasoning that are beyond the scope of classical logic. So to address this, there's a whole approach about computational models of argumentation. There's two basic levels of this. What I'll do is I'll say this very briefly, and then I'll give you a short example to show how this gets worked out. There's the abstract level, and then there's what's called the instantiated level. So the abstract level, which I will give you an illustration in a moment, is that we talked about arguments as being atomic objects, entities that are in attack relations. Again, I'll show you what this looks like in a picture shortly. We have a way of analyzing these kind of graphs of argument relationships to determine what are called extensions or sets. These are essentially sets of arguments that hold together, that are consistent, that don't have any contradiction. And this is what helps us abstractly reason in the face of inconsistency. Then we have what's called instantiated argumentation, where we have knowledge bases, that is, statements about the propositions that are true or the rules that are true. Modus ponens is one of these reasoning patterns, and we can have the P's and the Q's as propositions that are true or false. Here we can have argumentation schemes. We can introduce proof standards and various kinds of things like this, as well as a variety of modes of attacking different kinds of arguments in different forms. I'll illustrate these things, but there are these two separations. There are these two parts of this computational model of argumentation, but you'll see that they get connected shortly. So here's the example that I have, and it's about a dispute concerning whether or not it's appropriate in a driving. I hope that you can read this. I hope that I didn't make it too small. I can make it bigger if that helps, but let me know if that's too small to read. So here we're talking about autonomous vehicles. And we're talking in the United Kingdom, there's the highway code. Those are the rules of the road. That's what you need to learn in order to get your license, right? And there are a lot of instances of driving which are left up to your judgment to a certain extent. There may be a law that says you are not allowed to drive your car on a footpath. So that's sort of seen as an absolute rule. And then it says, except in certain circumstances, right? So it's prohibited to drive on the footpath, except if, and then there comes some exceptions, right? So when would there be an exception, and how would that work? Essentially, what you'd have to do is suppose that you're driving and a child runs out into the street, and you swerve out of the way and you drive up onto the footpath, the sidewalk, and then you're taken to court. You know, you're caught by the police and you're given a ticket for driving on the footpath. That's illegal. You go to the judge and you say, Your Honor, yes, I did drive on the footpath, but I'll tell you why I did it. And I believe that one of the legal exceptions that I'm allowed covers this instance. So, for example, I thought the footpath was clear and there was a child that suddenly ran into the road. And so I swerved off the road and drove onto the footpath in order to avoid hitting the child. And so therefore I should not be convicted, okay? That's how to read this from the bottom two boxes up to the top box. So it's a justification for that box labeled A. And you could see that there's going to be what's called a rebuttal. There's an attack on the conclusion where somebody else says, no, actually, the circumstance is one in which, in effect, you should be convicted of the offense of driving on the footpath. And then I'm going to give you my reasons. The first one is that the traffic was moving slowly, so probably you had a chance to stop. And The other point is that there was plenty of room to maneuver on the street. That's the counterclaim, right? That's the way that an adversarial system would work. Claim and counterclaim, and each of the claims and counterclaims has their own justification here. This is an instance in which classical logic cannot work because there's a contradiction between the propositions. So the argument can develop further, right? So you can have this kind of growth of this kind of decision tree on both sides. Somebody, and again, in an adversarial context, there's attack and counterattack of certain parts of the overall argumentation here. So somebody comes back and they say, well, you said that the footpath was clear, that is C. I say that the footpath was not clear, and I say that, and I give my justification as E. A witness saw 3 children on the footpath drawing with chalk. So the footpath was not clear. Okay, so that's my counter argument to the claim that the footpath was clear. And if you think it through, if it is false that the footpath was clear, then the conclusion that I draw that I should not be convicted should not follow. I kind of removed one of the premises that supported the conclusion, and therefore my conclusion doesn't follow. Okay, so that you're trying to undermine each other's positions. We build this somewhat further. The driver claims, that should be a solid arrow. The new one. So D, the driver claims that he saw no one on the footpath. Okay, and if the driver claims he saw no one on the footpath, that implies the footpath was clear. And the idea here is that the driver can only go on the basis of their own perception. From their point of view, the sidewalk was clear. And so, if you were doing a bit of forensics here, you would have to go and try to investigate, what was the point of view of the driver. Maybe there were children on the sidewalk, but maybe they were hidden underneath something or obscured by, some other means. So you could have this counterclaim, right? So, and then we can build it further. So somebody wants to say the driver's claim that they saw no one on the footpath, so therefore the footpath was clear, can't possibly be true because the sun was in the driver's eyes. And so this reasoning from what the driver claims to what was holding can't be the case. It's an attack on the application of a rule. And the support behind this claim is that the sun was setting and the car was driving directly west, uphill into the glare. So the driver's eyesight was being blocked here. So this is an attack on an inference. And we can then also go to the other side and attack the other side of the argument, one of those premises. So there was a claim there was plenty of room to maneuver on the street. And somebody says, no, there was not plenty of room to maneuver on the street. And you notice that this is defense of the person who's being accused, right? Because they're giving a justification for why they couldn't maneuver on the street, right? So that they could not maneuver on the street. Why is that? Because K, there was a car driving up quickly on the right side, so they couldn't swerve over to the right side of the street. And furthermore, there was a car tailgating behind the driver, so that they were feeling forced to continue to progress straight ahead. And rather than going to the right and swerving across the street, or rather than suddenly stopping and having somebody crash into them from behind, they thought that they would swerve onto the footpath. So you see there's this whole construction of arguments and counter arguments that you can draw. So then the next step that we have is we abstract. This is where we move from the instantiated argument to the abstracted argument. We abstract these arguments to say we're going to kind of cluster them together into units. Argument A is one unit, argument B is another unit, argument C is another unit, argument D, and argument E. The reason why we organize it this way is because these units have attack relations, those dashed blue lines between them, signaling that something in one argument is attacked by something else in another argument. So we draw circles around these kinds of units. And from this, we go to this move of abstract argumentation, where we're no longer looking inside the nodes. These are abstract. We don't really look at the content anymore. We only look at these as if they are atomic objects. and the arrows between them are representing attack relations. And this abstracts from the content and abstracts also from the notion of contradiction to just reasoning over these graph relations. And we reason as follows. We have these ways of calculating something being in and out. We don't need to worry terribly much about that. But if something is not attacked, there's no arrow pointing at it, you are in. So C is in, it's colored green because nothing is pointing at it. There's no attack on it. A is out because C is in and C attacks A. We also know that since A is attacking D, but A is out, that we allow D to be in because there's now nothing attacking D. That is, the thing that did attack D, namely A, has been basically kicked out of the game, right? And now we have two choices about B and E. Either you can select B first, say that's in, and that attacks E, so E is out, or you can make the other selection and you can select E, so E is in, and E attacks B, and so that means that B is out. And so you have these two what are called preferred extensions, that is, sets of arguments that hold together without any attack and without any inconsistency between them. So we've got these two extensions. How do you decide? Well, there may be various preferences and interpretive rules that come into play at this particular point. So let's talk very briefly. Actually, somebody should remind me of how much time I've got, but I have just 2 more points to go through about this, but let me just hear from Juliano.
Adam, we have already exceeded the time, but you may go through these points.
Okay, so let me just, I won't spend much time on this. There's a whole discussion about argumentation schemes where, for instance, you have, let me do this one, expert opinion, where you have a pattern of reasoning that's very often used, for instance, in court. We have an expert witness, but what you know in an antagonistic context, that there's a cross-examination in effect of the witness. You're asking, are they really a witness? Are they really an expert in the domain? What's their status and these kinds of things? So argumentation schemes are another pattern of reasoning. And the other thing that there are many other legal argumentation schemes. And then we can also talk about rule preferences that hold between rules. And this also may be another way to sort of determine which is a winning argument. That is, it's a winning argument when the rule that's being applied has satisfied one of these preference rankings. And there's also a related notion of standards of proof that are also tied to abstract argumentation. And there's a lot more about argumentation that I certainly won't talk about. And that's it. Thank you very much.
Thank you very much, Adam, for this introduction to the subject of argumentation logics and argumentation systems. There is one question from the audience, which is if there is any practical implementation, computational implementation and application of these argumentation systems.
Depends on how practical you mean is practical. Not yet really. There had been various efforts over time to make practical tools. One tool was called Rationale. And you can also find these sorts of tools available for teaching reasoning in schools. So it's not just for legal practice. One tool is called Rationale. They had a commercial product. You could make beautiful graphs, relate them to text. And the problem is that it takes a lot of work to create one of these argument graphs. And as I'm sure you could imagine, if you have a legal dispute, these argument graphs can become very large, very quickly, and very complicated. And they take a lot of effort. And the question really was, what is the added value given the work that you have to put in of the argument graphs? There have been other efforts to apply this, to use argument graphs in legal contexts to present the structure of arguments both to the judge and also to the jury, because it kind of makes it a lot clearer. And again, there's a lot of work that has to be done. So the challenge for argumentation in this, using these kinds of graphs, is to develop tools that facilitate the transformation of an argument from the source, whether that's an argument in court or whether that's an argument extracted from text, into an argument graph, so that it's the creation of arguments is much faster. So it hasn't been successful yet. The inspiration is clearly there, the use case is clearly there, and people are doing a lot of work to find this way to facilitate the creation of argument graphs from source material.